All right, class, settle in. Today, we're diving into something absolutely fundamental, Article 13. Now, if you think of the Constitution as this grand fortress protecting all of your rights, well, you can think of Article 13 as the ultimate guardian at the main gate. Let's get right into it. So, let me just start by posing a question. What actually happens when the government, the very body that's supposed to make and uphold the law, passes a law that violates your most basic fundamental rights? I mean, what's the safety net? What's the backup plan? Well, that backup plan, that is Article 13. Okay, so here's our roadmap for today. First, we'll talk about why Article 13 is basically the Constitution's guardian angel. Then, we're going to get into this critical difference between old laws and new laws. After that, we'll unpack three major legal doctrines: the eclipse, dead on arrival, and saving the good. And of course, we'll wrap it all up with the ultimate exam tip that I know you're waiting for. So, first up, the Constitution's guardian angel. And look, I'm not just being dramatic with that title. It really truly captures the absolutely vital role that Article 13 plays in our entire constitutional system. Now, if you're taking notes, and you really should be, I want you to circle this, star it, highlight it. Article 13 is the constitutional basis for judicial review. So what does that actually mean in plain English? It's the power source. It's the specific clause that gives our Supreme Court and high courts the authority to look at a law passed by Parliament and say, you know what? No. This one crosses the line, it violates a fundamental right, and therefore, it's void. All right, moving on. Now, this is where things get really interesting. Article 13, you see, doesn't treat all laws the same way. It kind of has a split personality. It makes this huge distinction based on one single critical date, January 26, 1950, the day the Constitution came into force. Remember that date because it is the key to understanding everything else that follows. Okay, so just look at this table. It lays it all out beautifully. On one side, you have the pre-constitutional laws, all that stuff that was already on the books before 1950. Article 13, Clause 1 handles those. On the other side, you have the post-constitutional laws, anything made after 1950. For those, Clause 2 says the state is straight up forbidden from making any law that messes with fundamental rights. But here's the real kicker. Look at the bottom two rows. For the old laws, we use a concept called an eclipse. They just become dormant. For new laws, they are considered dead from birth. Two completely different fates. Let's dig into what that means. So, let's tackle our first big legal tool, the Doctrine of Eclipse. Now pay close attention here, because this applies only to those old pre-constitutional laws. And the name is actually perfect. Think of a solar eclipse. The sun doesn't just disappear, right? It's still there, it's just temporarily hidden by a shadow. That's precisely what's happening to the law here.
So, here's the crucial point. The old law isn't erased. It's not wiped off the statute books forever. It just becomes dormant, inactive. It's been cast into a shadow by a fundamental right that it violates. So, it's still there, technically, but it's unenforceable for as long as that shadow is cast over it. And the classic case that really cemented this idea is Bakaji Narayan. So here's what happened. There was this old law from before 1950 that gave the state a monopoly on road transport. Well, once the Constitution came in, that clashed with the new fundamental right to business. So the law went into an eclipse. It became dormant. But then later on, a constitutional amendment was passed that actually permitted state monopolies. And just like that, the shadow was lifted. The Supreme Court said the old law automatically revived. It just came back to life. No new legislation needed. It was just waiting for the eclipse to end. Okay, so that's how we handle the old laws. But let's switch gears. What about the new stuff? What about a law passed in, say, 1965 or 2015? Well, for these, the court uses a much, much harsher doctrine. We can call this one dead on arrival. The key legal phrase here is void ab initio. It's Latin, and it means void from the beginning. This isn't about being dormant or asleep. This means that if a law made after 1950 violates a fundamental right, it is considered stillborn. It never had a legal pulse. It was a complete nullity from the very moment of its creation. So let's compare them directly. It's really simple when you see it this way. Eclipse, that's for the old pre-constitutional laws. They're just dormant and they can be revived. Void ab initio, that's for the new post-constitutional laws. They are dead from birth and can never be revived. Getting this distinction is absolutely critical to understand in Article 13. And the landmark case that drew this line in the sand was Deep Chand. Here, a post-1950 law was found to be unconstitutional. The state actually tried to argue, hey, a later amendment should revive this law, just like in the Eclipse case. But the Supreme Court drew a hard line. They said absolutely not. They ruled that the Doctrine of Eclipse simply does not apply to post-constitutional laws. This law was dead from the start and could not be brought back to life.
So we know a law can be dormant or it can be dead. But what if only part of a law is bad? Do we have to throw out the entire thing? Well, that's where our third doctrine comes in, the doctrine of severability. You can think of it as a form of judicial surgery. The principle here is really simple and pragmatic. The court doesn't want to use a sledgehammer when a scalpel will do the job. So if it can surgically remove the unconstitutional part of a law without killing the rest of it, that's what it's going to do. The goal is always to save as much of the valid legislation as possible. So how do they decide? They use this very clear logical test. Step 1, you find the bad part. Step 2, you ask, can we actually mechanically separate it from the good parts? But step 3, and this is the most important one, after you cut out the bad part, does the law that's left over still make sense? Does it still fulfill the law's original purpose? If the answer is yes, they sever it. But if the good part becomes nonsense without the bad part, then the whole law has to go. The classic example here is the RMDC case. There was this law, the Prize Competitions Act, and it regulated two things: competitions based on skill, which were totally fine, and those based on gambling, which were not. So the court found the gambling part unconstitutional. But instead of throwing out the entire act, they just neatly severed the provisions related to gambling and let the rest of the law, the part about skill competitions, survive. It was perfect surgical precision.
All right, we've covered a lot of ground today, so let's pull it all together into a really concise summary. If you're studying for an exam, this next slide is exactly what you need to remember. Okay, here it is, your perfect short answer. Start with judicial review. Article 13 is its foundation. For pre-1950 laws, you apply the Doctrine of Eclipse and you cite Bikaji Narayan. For post-1950 laws, they are void of initio and you cite Deep Chand. If only part of a law is invalid, you use the Doctrine of Severability and you cite RMDC. And finally, the crucial exception. Article 13.4 says that constitutional amendments are not considered law under this article, which of course raises a very, very interesting question.
And that leads us to our final thought-provoking question for today. If Article 13 can't be used to challenge a constitutional amendment, does that mean Parliament has unlimited power to change the Constitution? I mean, if an amendment tried to abolish democracy itself, what could possibly stop it? That question, that leads us to an even deeper, more powerful concept, the basic structure doctrine. But we'll have to save that one for another time.